So this is actual legislation from England, right? Although it is 1837 legislation, but the thing is, what is the legal system? What even is law in this country in the legal system, right? Taking into account that the right to bring a suit is for every citizen. Every citizen has the right to bring a suit. Well, I mean, what are the police even there for? The police don't operate completely independently from citizens. It, I'm starting to think that it's a miracle that the police do anything. Almost that you can't pick up the phone and dial 101 or what used to be 999, right? Without any citizens, there isn't any crime or offences, right? Because citizens are the only people who can commit a crime, right? If there were no citizens, right, the police would be walking around with nothing to do, right? Unless they just wanted to prosecute each other, which I seriously doubt they're going to do while they're all on duty, right? If you remove citizens, okay, you've got police on patrol in a deserted environment with no humans, right? It means that it would be like a wilderness, right? They can't arrest anyone or charge anyone. Now, they're not going to arrest and charge themselves when they're on duty unless they have infighting, right? So there's no job to do, right? But the police are not there as a military force only to arrest, charge, and prosecute citizens, right? Because it is the citizen who is meant to report a crime, right? It's not the citizen who has no right to report a crime or no right to prosecute a charge or no right to bring a civil suit through the civil courts, right? It's not the police's monopoly or sole job, right, for law enforcement. And this is a problem that I think we've got in the modern day. The court staff, the court staff, clerks, receptionists, justices of the peace, district judges, right, and the police, they seem to think that the law is theirs, that everything is theirs. No, the taxpayer, the citizen, right, pays for the police uniform, buys the police uniform, pays the wages of the police, right, and pays for the court building and the court service, right, because the law is made and enacted for the benefit of everyone, the citizens, because we vote for the laws, right? And everyone is supposed to have a right to be judged by their equals, their peers in a court of law. Although they've taken the citizens out, they've taken the jury out of the magistrates' court, the lower court, and only in the Crown Court with the circuit judges, right? Now, that means that it isn't electors, citizens, who are the ultimate judges of citizens based on evidence and a due process of law. What we've got are justices of the peace who are volunteers and not actually legally trained. They've got a legal advisor. They don't have to be King's Counsel standard of law, and a district judge. And now these justices of the peace and the district judge believe that somehow they are somehow some kind of superior persons or beings, right? And that the public, the electors, are nothing, right? unless they're victims or they're victims of naughty electors, right? Now, this is the thing, right? The Crown Prosecution Service are just lawyers, barristers. They were only invented in 1985 as a organisation, right? Paid for by the taxpayer. They prosecute cases, but they've become a body under a rank and file system, right? And it's a regime of barristers who have got a monopoly in all the prosecutions in England. When, prior to that, the police only instructed barristers and lawyers, right, to prosecute for them, but in cases brought by the public. Now, going back in time when there were less and less and less police, when there were sheriff, constable, and bailiffs, right, or civil suits were arrestable. There was hardly any difference between civil and criminal complaint or a civil complaint, all arrestable by the police. That means most of the county court cases were dealt with by the police as well as the magistrates court. It was all together, right? And there weren't all these police constables everywhere. There was only sheriff, constables, and bailiffs of very few number at the sheriff's office, right? Now, anybody could go with evidence and a complaint in writing with witnesses or oath to the sheriff's office, right, and get a warrant for the arrest of any person if they provide evidence for either a criminal complaint or a civil suit, right? Now, when the police issue the warrant, and this is not a warrant by a court, a search warrant, this is like an arrest warrant, right? Any person can go and arrest them, right? Or they put wanted posters up, and then anyone can, that means anyone is able to go and arrest that person or pursue obtaining them, right? Now, or apprehend them. If you are an old woman, right, or a girl, you're not going to go and arrest a big guy, right? Or if you're an old man, or if you are a little kid, you're not going to be going to arresting a big rugby player, right? Now, that's the whole point in getting the sheriff to go do it, right? Go getting the sheriff or the bailiffs to go with you to arrest someone, right? If you cannot handle or tackle them, right? If you are a grown man, right, then you go with a warrant and you go can apprehend or arrest them, right, and take them in. That's the point, right? The law is for us to use. Now, the problem is that now we've got the police to do it because we pay them to do it for us. It's not the police's law. It's not for them. It's not their law, right? We're paying them because we're doing other jobs like, butcher, baker, candlestick maker, right? It's not the police's law, and the law isn't for the police, and the courts is not for the police or the justices, right? It's for the public. It's for the electors, right? Who are meant to be in the court at all levels, and they're the judges, right? Because they are sworn in to decide, right? So these justices of the peace and district judges, right, at the moment, they're getting carried away with exactly what their role is and who they are. And, without a legal advisor, a lot of justices of the peace are clueless about the law and legislation. Yet, this is what's ending up perverting justice and the legal system. Now, I had an intuition. I had an intuition all along, the whole way through, right? I knew just by intuition, by intellect, by intelligence, by understanding, by knowing. I knew that in a court, right, when the public go in to spectate and watch, they're allowed to be in there. There's a public gallery, right? They've got a legal right to be in there. And there's meant to be a jury in there as well, right? Jurats, even at the magistrates court level, supposedly. And there's a prosecutor, right? But they're acting on behalf of the public's interest. And the case is against somebody who put a complaint in, the complainant, right? Now, true, there's got to be a lawful due process, right, in a court. But I knew that if there's something going wrong, something not right with either the prosecutor or the judges, like they're not following procedure rules, or there's some overriding objective being ignored or omitted, or they're refusing to act in the interest of the public according to law, right? I knew and know that there must be a way where someone can do something, right? We're not helpless. The public electors are not futile, helpless, disabled. They don't have a disability, right? And I knew that it must be possible for them to speak and say something, right, in a court, regardless of, procedure. Well, in somehow, somewhere in the law or in some procedural or magistrates court act or criminal procedural or somewhere in the law, there must be something that they're not in a court and they're not completely retarded, disabled, handicapped, incapacitated, right? If they are witnessing a miscarriage of justice or something, some error, like the defense solicitor, the prosecutor, the justices, something, if it is known and understood that there is a major error being witnessed or occurring, the public, the electors, the public interest cannot be disabled and incapacitated, right? And I knew this from intuition, because at the end of the day, it's the king's writ, it's the king's process, and these are meant to be the justices, particularly with the circuit judges, the king's judges on the Crown Court Justices Circuit. But the Magistrates Court is meant to be the common law. It's meant to be summary offences, right? It's not meant to be. They're not the circuit judges of the king, but they're now the Magistrates Court is, it's got the king's arms on it, but it's still meant to be the common law of the local people, and it's still supposed to have a jury, and those jurats are meant to be sworn in to try the case according to law and evidence, but also the jurat's oath, and you can read this in National Archives, the oath of the jurats, which is meant to be the jury that you have at that level, at the lowest level, not Crown Court jury, right? The what was the Magistrates Court was that they will uphold the rights and liberties of the town and the subjects and the law, right? That means that they know what the rights and liberties of the subjects are, right? They've got the jury are supposed to know all the rights and liberties of the subject. Particularly because some of these jurats were they weren't randomly selected like at the Assizes Crown Court level when it did its circuits. They were kind of like full-time jurors. They were like sworn in for longer periods of time, so they know all the laws and rights. They don't only know the law that the prosecutor decides to tell them. They don't only know the law which the defense barrister presents or tells them. They're meant to know and understand all the existing rights. Like now in court, if someone has an accident in the court, they know what rights people have, for medical and emergency rights, that they're known, right? No one questions those rights. If there's an accident or injury in the courtroom, people just, they can intervene in proceedings. Why? Because there are rights. That if there's an accident in the courtroom, right, overriding objectives come into play, and no one questions them. No one questions them or has to argue what they are, those rights, because they're kind of like second nature. If someone has an accident in the court, they naturally phone an ambulance or naturally do things, including getting security guards if there's any. But this is a thing with security guards. The security guards are only there if someone is disrupting or disorderly, or if there's some kind of assault or fray or incident. Actually, speaking and talking and voicing, which we're about to explain in a second, is an actual inherent right and ability, not disability, of the subjects. Now, in the justice system, from way back to the time of Magna Carta, we've got this Statute of Westminster II. The Statute of Westminster II is contemporary with the Magna Carta, 1297, when it actually was put into law. Now, this is important, right? Because if any judge or justice, right, refuses to recognise a right or is found to be not applying the law properly, right, they can they can write a complaint out against the judge, right, there and then, and get him to stamp it or sign it, right, and then that is sent to the king to summon that justice to the king to answer to the king, because it is the right of the subjects to petition the king, right? Any of the citizens, including with a complaint against any of the judges, right? Any judge, but you can do it there and then. You can any citizen can have a complaint against that judge there and then, and put it in writing and get that judge to sign it there and then, and send it to the king and summon him, right? Now, that is from way before the 1688 Bill of Rights, but the 1688 Bill of Rights makes it explicitly clear that it is the right of the subjects to petition the king. Well, you can petition the king about any of his justices, right? Particularly if you're witnessing his justices miscarrying justice, or a crown prosecutor. Any citizen can petition the king about those justices, and that goes back to the Statute of Westminster II, because it's called the Bill of Exemption, right? Now, so that is the link between every judge and the king. They all like to parade around in these courts, including magistrates' courts as well as crown courts, with the big coat of arms and emblem on the front of the court, the big crown and the lion and the unicorn. There's one at Ashton Underline, right, in Staffordshire, right? There's one at Ashton Underline in Staffordshire, a big emblem on the front of the magistrates' court with a crown and a lion and a unicorn, right? It's royal. They love it. But whenever you mention the king, they seem to suddenly go glaze over and go blank. King? What king? What king? There's no king around here. There's nothing royal here. yet they are showing off the emblem on the front of the building. And this is all, the law of the land. As soon as you mention the king, it's like they want to take it off the building and put it in the back pocket and hide it. Or, say, we've got nothing to do with the king, right? Now, this is the thing, right? And let's get this clear, right? Who these justices are working for. Now, what we've got on this page here, and I've been talking for 20 minutes and 30 seconds now, this is English law, and in Scotland as well, right? This is 1837 legislation, right? From the 1837 acts which were passed in Parliament, right? Now, this is a legal basis in law. A legal basis, an enactment in law, right? And it's very clear. You can see the first word, and be enacted, right? Yet, none of the justices or magistrates want to acknowledge law or rights. It's like they don't want to know the law. They don't care about the law. They're not interested in law. Unless a Crown prosecutor comes into a court and submits it through a computer or puts it on a table. They want to put their fingers in the ears. No one else has a right to speak, be heard, be recognised, acknowledged, understood. Only the Crown prosecutor is to be acknowledged, or the defendant, and it's a miracle to God that even the defendant's own statement is even acknowledged. And if you get a chance to speak when you're spoken to or whatever, right? Or if you get a lawyer, if your lawyer's not completely and utterly corrupt and incapable and don't even really actually even know the full extent of the law, right? Now, this law here explicitly and clearly states that electors, voters, registered citizens of the country, right, of the number of 3 or more as a body of people, right, can assume and intervene in prosecution, right, and take over it. Or at least make a submission statement, right? It means that you can be heard. It means that you've got a right of address, permission to speak in any criminal case, right? Where a prosecutor is either incapable, incompetent, or unwilling, right? Well, let's pick a random example where that might occur. Oh, if the citizens might be witnessing rights of defendants not being recognised through overriding objectives, like, for example, political rights, the needs of other cases, other causes, maybe parliamentary causes, maybe parliamentary cases, right? Now, I've checked. There aren't any prescribed forms to take over a prosecution case, right? Which means you don't need a form. You don't need to fill a form in to do it. Now, usually, the Crown Prosecution Service take over prosecutions if they want to. Believe it or not, the public have a legal right to prosecute, to bring their own prosecution privately themselves or with a lawyer, right? And if the Crown Prosecution Service, apparently they can take over a prosecution, right? If they want to, using taxpayers' money. Why? Well, maybe they should have been doing it in the first place. Maybe the taxpayers shouldn't be using their own money to do prosecution because that's what we pay the CPS for, right? And maybe they've got far enough in it to prove that there actually is a case that they should have been doing, right? Now, that means the Crown Prosecution Service don't actually have a form to take over and assume a prosecution. Well, how do they do it? Well, they just start making representations and the other party stops. And if the other party, saving money, and because the CPS are going to do it now, then good for them. It's going to save them money, right? And if they want to argue about who's going to take precedent, then I guess they can argue it with the judge. But at least, both parties will be having an audience, seeing that, if the public started it, then the Crown Prosecution Service will just start making representations, and then, maybe the other party will withdraw. But the key point there is a legal right to enter representation, and the judge to recognise it as a legitimate representation and a right to make a representation in that case, which means that it's not just a complaint through the system. Oh, we can't act on complaints. We can't take legal action on complaints. It will just be recorded. You don't have any legal jurisdiction or authority. Tosh, 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 right? And this is the corruption and the lies of the Ministry of Justice and of the court staff, trained to be corrupt, trained to lie, because they don't know the law. They're not interested in legislation. They're groomed, trained, obey, 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 obey the superior authority, not the electors, the citizens, a body of electors who are the public interest. The Crown Prosecution Service assume they're acting in the public interest. They claim they're acting in the public interest, right? Who are the public? Who are the public? They are a body of electors, a section of the public or the public at large. That means if you've got 3 or more electors, they're clearly acting in the interest of the public or a section of the public. And therefore, they've got a right to have an opinion to the CPS or to the court. Now, if that section of the public are of the opinion that something is not right with a prosecution case, is not right with proceedings, if something is being done wrong, if overriding objectives are not being followed, if rights aren't being recognised either by the prosecutor or the judge, right? They've got a legal right, therefore, to speak and be heard, right, in a court. And if the justice refuses to hear them or denies their claim, then they can write a bill of exemption with their claim on it, which the judge has to sign, and they can send it to the king, and he will summon the judge to check the law, because it is the right of the subjects to petition the king about any business of the king, including his justices, right? That means that the citizens' electors are the interest of the public, right? And the current district judge and justices of the peace, who actually are, I've never met anyone in my entire life who knows less about the law in my entire life than justices of the peace. It's like they're strategically placed there to not know the law. They're strategically placed there to not know the law, right? So, which is enabled it to become so perverted that they become like these emperors in China, these little children in these Chinese dynasties, like the 8-year-old emperor sat on a throne, right, where they command all, but yet they know nothing, right? And this is where we are with these justices of the peace, particularly like in Westminster Magistrates Court and some district judges as well. In fact, probably nearly all of them, because they think they don't know who they are and what they're doing when they're dealing with the public. Now, if there's been a murder or a housebreaking or something of such magnitude, why would the public have an interest in intervening, right? Now, if there is an existing political case with the Parliament of England, which used to go through the courts, right? It used to go through the courts to get to Parliament, so it had to be recognised, right? And these legal cases to the Parliament are not being recognised by the courts, right? Well, then the electors have got a legitimate reason for concern. Why any rights which might be attached or process attached to such causes or cases should be recognised by the courts, right? Particularly, we're talking about existing political cases which actually exist. And it seems that the magistrates' courts don't seem to believe that such a thing exists, that such a thing actually has an existence in this country. Like, when it does, it has an existence, and they're going to have to start understanding that it has a legal existence. It is a legal process of law. It's a case, right? They're going to have to start recognising cases of currently which they don't seem to know anything about. Because after 1986, the formal process for the recognition of these causes through the courts was repealed. Yet they still exist, because you don't need to go through a court with them. You go straight directly to Parliament. They don't have to go through a court. So after 1986, courts don't deal with them. They don't seem to know anything about them. They've gone off the radar. So what we've got is a memory lapse, a memory loss, a deficiency, a defect, right? And it happens to be when the Crown Prosecution Service were invented in 1985. And they're controlling and taking over all of legal process and proceedings, right? Now, and also remember that the local council actually had officially recognised justices of the peace. So if you've got a cause to Parliament, which is a case in matters of the church, the whole country, or the law of England, it usually would go probably from the justices of the peace in the local council to Parliament, not necessarily through, magistrates court or county court. Although you probably could go to a county court now, because it's a claim from citizens, but not necessarily in a criminal matter. Effectively, you could go to a county court to get it recognised, and then you could get some documentation. But it's not required. It's not needed, and this is why, because currently criminal magistrates courts don't know anything. They're retarded at the moment. They have a retardation in their knowledge of law, and a retardation in the area of law which is concerned. And the CPS do as well. And when you try and explain and tell them, they are resistant. They are opposed. They are refusing to. They don't want to know about it. Why? Because it intervenes in their practice and procedure. right? Now here, in this law here, it states that a body of 3 or more electors has got a right to make representations to a court at any time, okay, on behalf of the public, whether the CPS like it or not, whether the courts like it or not. That means that it has to register. Now, I don't know whether these courts are being ignorant, whether they're being bigoted, whether they're being aloof, or whether they're just being uncooperative, or whether they're just disregarding everything, right? But it's meant to be regarded. Now, I always knew that from weddings, right? When people get married in a legal ceremony, in law, a civil legal ceremony, which is not conducted in a county court, it's conducted in a church, but it's matters of church, and it's a legal process in England, a jurisdiction of law, whereby ordained priests with a jurisdiction of law in England marry 2 persons into a union. And that is a legal proceeding in law. And if any person does object, right, or have anything to say or statement to give regarding those legal proceedings, they can speak thereforth during those proceedings or forever hold their peace, right? The king's peace. Now, I knew and I know that there is a legal basis behind that, because it is the right of the public, right? And it's the king's church and ministers, right? Now here it is. This is the legal right for a body of citizens to speak and be heard in a court in regards of legal criminal proceedings, right? Can be criminal proceedings. That means that if anyone has got anything to say or any evidence or any complaint or grievance about a defect in those proceedings, a right failing to be recognised and overriding objectives, or a law being disregarded, they're allowed to speak and be heard in the court and recognised by the judge, right? It's an overriding objective, because the jurors who have been removed and aren't there anymore are meant to know all the rights, and the jurors are meant to be representing the citizens and the public interest. Now, if 3 members of the public or a body of the public happen to know these rights, which are meant to be known, then they're not being applied, they've got a right to speak and have them heard, right? Particularly when it comes to like the right to petition and, you know, things like the Public Meeting Act. Basically, the laws that come into force around things like when you've got a parliamentary cause and petitioning, which is meant to be a protected process, mainly because the courts aren't allowed to intervene. The courts aren't allowed to intervene or supposed to intervene at all, because it's already an existing case to Parliament, right? And they don't have jurisdiction on it. So that would be, of all the possible reasons why anyone would want to do this, that's the top of the list, right? It's the primary main reason why anyone would probably want to use this, because, you know, because it affects a number of people, whether it's a number of petitioners, a body of people in the public in a cause or campaign or whatever, or just upholding the rights of the realm where they're being disregarded, right? So here it is. This is it. And I actually tried this recently at Westminster and we've been ignored by this Turner guy, and then we got set up with this Sternberg, right? So I was right. There is a legal process existing in law where if you are in a court and you are in shock and horror that such an abomination could be happening, that some law is being ignored or disregarded or failing to be recognised, and it's nothing to do with the evidence presented in terms of statements and so forth. It is a an actual overriding objective, a right, one of the statutes or Magna Cartas, any overriding objective or a point of law which is of main concern, which is being completely and totally undermined, right? If it's a point of law or a right, you can write a bill of exemption out. Now, that bill of exemption, actually, like I said earlier, it summons the justice to the king. And then basically the king's saying, like, this is the law, right? You're forcing that justice to have to check it, and not with the legal advisor. The legal advisor is not the king, right? The legal advisor is going to be there so they can check laws. But a good judge or justice of the peace who was educated in the law wouldn't need a legal advisor because they would just know all the law anyway. This is the problem. It's almost like their brain's been taken out and put on the table at the side of them, and they keep having to speak, double check all the time with their brain. Now, they think they know the law. They think they know legal process. They think they've been to the college in the judicial Royal Courts of Justice and have been trained as a judge. They think they're doing things right. They think they've been told how to do this or that right. And they think the CPS know what they're doing, or they think that they know all these other lawyers who are getting paid thousands and thousands and thousands and thousands and thousands and thousands of pounds, right, to represent people when they're doing it wrong. They're doing it wrong. So wrong. Absolutely wrong. Not even in the right page of the book. Not even with the right book. Right? Like, members of the public engage in an activity where laws A, B, C, and D are in use and effect. And then a lawyer comes in and defends them using laws X, Y, and Z, right? Which are not even, I've been trained how to do it. I've been told what to do when we're facing a criminal charge. Yeah, but laws A, B, C, and D say they can't be a criminal charge for the reasons set out in laws A, B, C, and D. So why is a solicitor coming in and defending with laws X, Y, and Z, which are not even on the right page and not even in the right book? Because that's all they know. They know X, Y, Z. They don't know A, B, C. Right? And they'll be lucky to get a D because they have not got a clue what they are doing. They're not legally, proficiently capable of doing it, which means that it's all wrong. But yet they're acting and conducting and behaving themselves as if they are the experts in it, and actually also exhibiting, controlling an authoritative behaviour, right? When they're wrong. And it's so serious that they're wrong, abuse of process, perverting the course of justice, professional negligence, that they formed a cult, a authoritarian cult, dominatrix cult, where they know it's so serious, what they're doing is wrong, that they have to command their victims into a submissive, obedient, submission, because the consequences of what they're doing, should the actual real truth and fact ever be revealed in a court, or acknowledged or heard, is immense, because they're all high-level criminals of a immense magnitude, organised, racket, orchestrated, protecting each other. And that is what's happened to the Crown Prosecution Service, right? They have become a body with their own interests, and they're protecting each other. And that's what the police are doing as well. It means that they've assumed they've taken over control from the public. They're not acting in the interests of the public anymore. They claim they are. They might think they are, or some of them think they are, but they're not. They're acting in the interests of the police, not in the interests of the public. The police claiming that they're doing good for the public when they're actually not. They're doing some good, and then they're doing bad as well. And the same with the CPS. And this is the problem. They're so big now that they've got their own interests. They've got their own interests as a body, and unfortunately, that body is under a hierarchy of authoritarian direction from above. And it's under the Attorney General of England, unfortunately, and the Directors of Public Prosecutions, and the Chief Police Officers, and the Inspector of Police, and the Police and Crime Commissioners who are affiliated to Conservative or Labour Party. And it's not the public anymore. They're not acting in the interests of the public. They're acting in the interests of a hierarchy of military command from the ministries of the government and ultimately from political parties, right? Now, obviously, there are some public whose interests they're acting in. Victims, if it's, victims of these serious crimes that we're all scared of. But this is the problem. When the citizens are victims of anything, the citizens as a body can act to Parliament as victims, as with a grievance. And at that point, they are bringing a cause themselves, not the police, not the CPS. They have a cause and they are in a process, right? And that is the interests of the public. And the Crown Prosecution Service are acting against the interests of the public if they intervene. And the police are acting against the interests of the public if they intervene. And it is in these court sessions, which are actually an unlawful intervention, where the public have a legal right and authority to form a body and make a representation to intervene themselves, to stop it against their fellow citizens, which is what we've got with these political causes, right? And if the justices refuse to acknowledge and accept these representations, which can be voiced in a court, then you can write out this bill of exemption and summon them to the king. Although we're meant to have Judicial Conduct Investigations Office, but they're not doing anything, right? And I've actually had enough now. I've actually had enough of these justices of the peace. I've had enough of these district judges because they're utterly corrupt. They are absolutely and utterly refuse to cooperate. They refuse to listen. They refuse to acknowledge law. They don't know the law. They don't know it. And even when they see it, they refuse to comply and apply it. And they're in the job for so long. When you're dealing with criminals all the time, actual real crimes, unfortunately, these persons assume that every single person in the court is a criminal until proven otherwise, and they don't actually understand that the public it's the public who have got powers when they join together as a body, and they're the ones who bring a cause or case. The Crown Prosecution Service are only acting because the public pay them to act for them, right? And you don't need to be a lawyer. You don't need to be a Crown Prosecutor or a police officer to bring a cause or case. You only need to be an English elector and form a body. And if you know your rights, and this is the thing, they're saying that we don't have any rights. And that's actually contempt, and it's contempt against the Great Charters of England and the statutes, which have to be supposed to be enforced by bishops when they've been broken, because we've got evil. There is actually, and it's not joke, it's serious. Evil justices and ministers and councillors. Why would it say councillors? Well, actually, the local councillors, the aldermen in the council chamber, supposed to have a part to play in petitioning. They do have a part to play in causes of political nature in the local council when people are petitioning in a local government. But when it comes to central government, it no longer goes through the local council anymore, or through a court or the county court. The only time that it gets blipped on a court, the only time it gets scanned or pops up on the radar on a court is if these persons end up facing a criminal charge, usually, or if a local council tells someone to remove a banner or a notice or sign like Dr. Tess Lowry, when they don't have a right to do that, to tell them to remove it, because if it's a matter to the Parliament of England, and these are the laws, like the Control of Advertisements 2007. That's a law that was made at the time when Keir Starmer was removed from representing a protester for climbing up somewhere and putting a sign or banner or something on, and he got put in charge of the Crown Prosecution Service. But they made a special law for these type of causes. Someone went to the trouble to make legislation in 2007 so people with cases to the Parliament could put up signs and notices in public. But it's not even acknowledged. Someone went to the trouble to do that, but it's getting completely and totally ignored by the local council, by the CPS, by the police, and I don't know why that is. They're not taught it in their college. Someone in government made that law. If they didn't want people to have rights, they wouldn't have made it for them. And I don't know why it's not being recognised, and no one is doing anything about it. Now, ministers in government made that law and put it through only in 2007. It's not that long ago, right? And I think it probably had, the timing of it clearly had something to do with that Keir Starmer case, which is a key thing. Then he being invited to lead the CPS when he actually abandoned that case for the protester halfway through. Now, you might think, well, we want to recruit Keir Starmer to lead the CPS, and we'll screw over all these protesters. We won't give them any rights. No, they didn't do that. They didn't recruit Keir Starmer to lead the CPS and screw over protesters. They recruited him to the CPS, and he abandoned his case. But someone in government gave protesters rights to put up banners. But some local councils know the law. Most local councils use the Act for itself, for themselves. No one's prosecuting the local council. No one's even trying. If someone were trying to prosecute the local council and giving it a go, if the CPS didn't have the monopoly on law, and if people weren't being extorted out of being able to bring criminal charges by lawyers from ridiculous prices, what happens if people were trying to prosecute the council every day of the week? They'd soon get to know what their rights were if someone were having a go at them, right? Having a try at them, but no one tries. They're not bothered. They don't care. I'm all right, Jack. We're the authority. No one challenges the authority. We can do this, we can do that, right? Council couldn't give a flying monkey's chuff about the laws and rights, okay? If someone were trying to prosecute the council, then they'd be bothered. And the police aren't taught anything to do with it because it's the council's area of law, right? Not the police's, because it's fines and civil. right? The police are only taught to screw people over with criminal charges, which is the Criminal Damage Act, right? So, if you're looking for the Town and Country Planning Act in the police, you won't find it because they're not taught it. It's like the police not being taught the difference between a man and a woman, right? They don't know what a penis is, they only know what a vagina is, right? Oh, we've never seen this before, we don't know what to do with it. This is the thing. The police only know the Criminal Damage Act. They don't know the Town and Country Planning Act 2007 properly, right? It's like male and female, civil, criminal, right? But they're just wanting to do everything with a criminal charge because that's all they know. That's all they're taught. Do it, do it, do it, do it, do it. It don't matter what it is, just do it. Do it, do them, do them. We don't care whether it's, man, woman, boy, girl, old man, old woman, just do them, do them, do them. They know nothing. All they know is what they've been taught to do people, right? They don't know, they don't get involved in civil anymore. When the police were arresting people and giving warrants out for people owing people money, right? All business at the police counter, civil and criminal, right? Then they would know about that. They'd have to know about that. When we've got the oaths, we will uphold the rights and liberties of the people. Yeah? But now it's split up, and this is the problem. Someone knows, right, about this blind spot. Someone knows that the police have got a blind spot, right? That there's a gap, right, between the civil and criminal. And someone is refusing to act. Someone is not doing something about it. Now, I would say that it's Parliament and the government, because in 2007, they know all about it. In 2005, when they're, updating the House of Lords, the Lord Speaker in the Parliamentary Papers Act, which, protects from civil and criminal charges, someone knew about it. Gordon Brown. I would like to probably suggest that Jeremy Corbyn knows more about it than he's saying. Yet Jeremy Corbyn, he's always popping up like a little mole, popping up here, popping up there. I'm a man of the people. Jeremy Corbyn, I'm a man of the people. I'm a man of rights. I go to protests. I go to events. I'm everywhere. I'm all around England. I'm at this Labour event. I'm at that protest event. I'm in Ireland. I'm at a campaign in, Newbury. I'm at a campaign in a Morris Dancing Festival. I'm at a campaign at a river barge thing. Jeremy Corbyn couldn't be... Where hasn't Jeremy Corbyn been at a campaign, right? But why is Jeremy Corbyn MP not acting when there's this gap? When someone knows about it, because they're putting these laws through and they're making these laws to be used in 2007, in 2005. But he won't act. He won't intervene. Oh, it's nothing to do with me. I'm at a protest, but it's nothing to do with me. But it is something to do with him because he's there. And this is the failure of these London Assembly members like Susan Hall and a lot of these councillors, like this Simon Forthrop. He's popping up at all these demos and protests, but he doesn't know the law. He's clueless about the law. No one's educated him or told him about it. There's a gap, and the problem with the Criminal Magistrates Court and the County Court is that they're only divisions of local council level law. The local council was all-encompassing, all matters, right? And it's been split off now into the Magistrates Court and the County Court, when it's all meant to kind of be one at the same level. And the local council are eager and willing. If someone owes the council money or a fine and they're not paying it, they're straight to the Magistrates Court. Oh, pick up the telephone. Pick up a pen, fill the form in. Let's get in contact with the Magistrates Court, right? But when there are protesters, when there are riots, they seem to have a mind lapse. We don't have anything to do with the Magistrates Court. We don't have anything to do with criminal proceedings. That's nothing to do with us. You know, oh, it's something to do with you when you want someone to pay money over, but when your local electorate, your electors who you're representing, have got an issue with their political campaign or cause, you don't want to lend assistance. Maybe you might be opposed to their cause. You're not acting impartially. You're not acting without bias. You're not acting as a facility for the public, like a public library or a public toilet or a public petitions committee in a local council. Maybe because it's Labour or Tory controlled, you don't want to help them out. You don't want to contact the Magistrates Court and say, oh, just a minute, what's going on with these, political rights under the Town and Country Planning Act. This is the problem with people like Simon Thorthorpe. It's I don't know whether it's a reluctance or a retardation. It's a bit of both. It's a bit of reluctance and a bit of retardation. Some of them have a clue. Some of them know a little bit more than they're making out they do. They're not all like Councillor King at Colchester Council, who he knows everything there is to know about the law and council and procedure. So something needs to be done about this, because I don't see the Lady Chief Justice doing anything about it. All I see is defiant, bigoted, and megalomaniac justices of the peace who aren't legally trained, who don't even get paid, who are volunteers, and district judges. And they also mock us when you have a go at them, when you have a try, because they switch them around and put ones with funny names in, like, Sternberg. First it's Turner, now it's Sternberg. We didn't manage to turn that case around, did we? Oh, now Sternberg's going to give the verdict. They're toying with us. They're playing with us, right? And there are ways and means to make these persons make them do as the public interest and the law commands. These people can be commanded by the law, and that's one of the things that the Bill of Exemption does. And that the public can speak in a court. A body of the public has a right to an audience in any proceedings. If there's a right that is failing to be recognised, for example, or a law which is completely being ignored or omitted or obliterated or whatever, disregarded or failing to be recognised when, it wasn't introduced by the defence lawyer, it wasn't introduced by the CPS. No, we're introducing it. The random selection of the jury, the jurats, right, will uphold the rights and liberties of the realm. The public, the jurats, will uphold the rights and liberties of the realm for the public in the public interest. And if they don't, then a body of 3 or more electors will act to uphold the liberties of the realm in any court in this country, and they will be heard in a courtroom by a judge with a representation, with a body of 3 or more people, according to this, which is effectively a petition, right, to the King's justices, right? So, if any judge wants to, get the security guards on them for heckling, you're not in contempt of court, right? You're not disrupting proceedings. You're not intervening in proceedings. You're not in contempt of court. You've got a right to be heard by the court and it to be recognised and accepted into proceedings. And I did know it all along, right? And this confirms what I thought. And if the justice is refusing to comply, you can make him sign a document to say that he disagrees with you, right? And you can't be arrested because you're petitioning the king's writ to the king through his justice. You're petitioning the king, right, about a justice misbehaving there and then, right? And you're not in contempt of court because it is the right of the subjects to petition the king, and all commitments and prosecutions for doing so are illegal. You cannot be in contempt of court as a body of electors for complaining to a judge about refusal to acknowledge rights, and you can get that judge's signature on that document, and you can send it to the king and have him summoned there, right, if he won't accept and recognise the rights, when the electors as a body are clearly to the understanding that they're being failed to be recognised, right? And I am sick and tired of these magistrates' courts. They're purposely, with strategic intention, designed now to be working at a retarded level, retardation, right? In order to prevent the truth and fact, retardation. And it's a retardation with a assumed authority, right, which is corrupt. A corrupt assumed authority. A corrupt assumed authority by persons who are not responsible or capable enough for the job, but who believe purely on their given position and authority that no one can challenge them, that no one has got any rights, when they couldn't be more wrong.